I appreciate you all coming, and I do promise breakfast is on its way. Okay, Brian, thank you.
Good morning, everybody. As Barbara said, my name is Brian Curley, and Joyce Schneider is here with me. We're both senior attorneys at Curley, Walsh, Matera, Supermani, right down the road here in Seaford, and we represent St. Joe's as well as several other Catholic Health Services entities. CHS is promoting a zero harm initiative, and what they want to do is eliminate any harm to any patient. And there's a good reason for that. One is we never want to harm a patient, and we want to do what's best to make sure the patient do well. And the second reason is a financial reason. Now, with the coverage the hospital has, the first $250,000 that's paid on any claim is taken out of the hospital. So I think the hospital would rather hire more nurses and hire more doctors and improve the plant rather than give money to someone who claims they were injured here. The new, I call it the new automobile accident case, is decubitus ulcer or pressure ulcer cases. When I first started in this business 35 years ago, there were very few cases involving pressure ulcer claims, and now there's as many of them as there is any other case in the industry. And the reason for that is Medicare is cracking down and not reimbursing hospitals for certain events that occur. Initially, what they said was, if a patient's called back to the OR within 24 hours of a surgery, Medicare wants an explanation as to why, and if they don't like the explanation, they're not going to pay for it. They call it a never event. I mean, it never should happen to a patient. And decubitus ulcers, even though they occur in spite of proper care, Medicare is heading in the direction of making that a never event. And plaintiffs' attorneys love that, because if they can get it to be a never event, then the mere fact that it happens improves their chances of success in bringing a claim against the hospital. And what we're going to do today is we're going to talk about the litigation aspect of it and the nursing care aspect of it. I'm going to talk about the litigation, and Joy's going to talk about the care. And then at the end, we have some nice pictures to show you about what these decubitus ulcers look like, even though you've seen them all, and how effective that is for a plaintiff's attorney in presenting that to a jury. And just a quick story. I had a case a couple of months ago rather, in Nassau County Supreme Court, and the pictures were gruesome. So I was picking a jury, and I asked the court, can I show the jury the pictures during jury selection? And usually that's taboo. But the judge said, okay, you can do that. I had 3 jurors, juror number 2, 3, and 4, who I thought were rock-solid defendants jurors. When I showed them the pictures, 2 of them said, I can't sit on this case. So the pictures tell the story. And we're going to get to that at the end. But for now, I'm just going to go through what our obligations are and how we can avoid the possibility of ending up in a courthouse testifying as to what occurred, okay? So managing risk, okay? So in litigation, what we want to do is be able to manage risk. And anticipation, meaning, okay, we have a patient here who's on a ventilator or who is not moving around. We have to anticipate, or has very poor nutrition as an example. We have to anticipate there's going to be issues with this patient's skin. We all know about the Braden scale and other things we do, the fall risk scale and everything else. We have to be aware of the possibility that something's going to happen to a patient. And we have to document. And we're going to get to that in a moment. Recognition. Recognition meaning if there is something that we see, and this is limited to decubitus ulcers obviously, but it goes into many, many other areas. If there's something that we see, we have to recognize what it is. As an example, decubitus ulcers generally will start as a redness in an area and then progress from there. So if we see a redness in the area, we have to recognize what it is and where it can lead to and take the steps to make sure that we treat it. Management. Get the people involved who should be involved. If there's a need for a wound care nurse, if there's a need for a doctor to intervene, get them involved and document that you got them involved, okay? And the last thing is reflection. At the end of your shift, and it's easy for me to stand up here and say this, I know you're very busy people, and I know your job, and I make this argument all the time, your job is not to necessarily keep the best notes, your job is to take care of the patient as best you can. But unfortunately, in these days, with litigation and with people suing at the drop of a hat, your job now includes making sure that you're making appropriate notes and reflecting on what you did and making sure you did everything you could for the patient. Now, in addition to caring for the patient and making sure the patient gets the right medication, you now have an obligation to manage someone else's risk. What is the risk of this patient developing a decubitus ulcer? And if there is a risk, what do we do about it? And who do we have to get involved, if anyone, or what do we have to do? All right, if there's an order in the chart that says turn to position the patient every 2 hours, most hospitals, including this one, will have a decubitus ulcer checklist where you have to document what you do. Please do it, because plaintiff's attorney's theories on these things is if it's not documented, it wasn't done. I have a case coming up for this hospital next week where the turn to positioning sheet and the decubitus ulcer sheet is filled out almost every shift, but there's 5 or 6 shifts where it's not filled out. So I can anticipate the plaintiff's attorney is going to point to those 5 or 6 shifts and say, the nurse didn't do it. Now the nurses are being very cooperative, and we're going to have to bring a couple of men to show this is what we always do. You know, my job is to make sure I take care of the patient. That's my first responsibility. You, as the nurse, and the physicians, and the PAs are going to be asked to take responsibility for caring for the patient. And what I mean by that is documenting what you do. And unfortunately, you may have to be here an extra 15 to 20 minutes to make sure your charting is appropriate. But charting is very important in this particular field, as well as other fields when we're moving forward. Okay? Responsiveness to the patient. Trying to bring a little humor in here. Yeah, I heard you ring the bell, but if you need assistance, push the call button. I actually had a situation where the patient testified at the deposition. I was screaming out and screaming out and screaming out. And when I went, and this is a long time ago in a different hospital, when I went to speak to the nurse said, I don't respond to screaming, I respond to the call bell. Okay, so nobody does that, but that's just a little bit of a situation where we have to make sure that we follow the rules. Okay, elements of malpractice, duty. Okay, you owe a duty to exercise reasonable care, and it's an interesting responsibility, and it's an interesting jury charge that the judge will give to the jury, and that is reasonable care as a reasonable nurse would give under the circumstances. So what happens in these cases is the plaintiff has to establish that there was a duty owed to the patient. And the duty owed is obviously making sure the patient gets appropriate care, the patient is turned in position every 2 hours, that the orders that are given by the physicians regarding patient care or the wound care nurse are followed. Okay? The second thing is a breach of that duty. Well, how do we breach the duty? The way we breach the duty is that we don't do what we're supposed to do. We don't turn and position the patient. We don't apply the proper ointment or cream to an area that they're concerned about. We don't get the patient in an appropriate bed. We don't report things to our supervisors or to the doctors so that we can make changes in patient care if necessary. All of that is breaching of a duty to the patient. Second thing is causation. Did this, what the plaintiff says, failure, cause an injury to the patient? Well, you're going to see in these pictures later that it's hard to dispute that these patients develop some gruesome areas of injury, and the onus, the burden of proof in this state is supposed to be on the plaintiff. It's been my argument for a long time, and it remains my argument, and that in these types of cases, the onus is on us to prove that we did everything right. Because when you get those pictures and you see what these patients, what the injury is alleged, we have to establish we did everything right. And that's when I get to the issue with documentation, okay? Now, just a quick thing of how a patient becomes a plaintiff, okay? Information, consent, trust, rapport, and continuity of care. Now, rapport is important. It's less important in a situation where a patient's in a hospital setting and is seeing a nurse than it is sometimes for physicians, because if the patient's going to sue the hospital, it doesn't matter whether they name the nurse individually or not. So if they sue the hospital is generally responsible for the nurse in most circumstances. But what happens is we have to communicate with the patient. We have to get the patient to understand, this is a good thing. They may forget your name, but they'll never forget how you made them feel. If you make them feel, as there's a commercial out there now, and the patient says, I think my nurse is a rock star because she makes me feel like a rock star. If you make the patient feel welcome and you make the patient feel comfortable, they'll forgive a lot of things that go wrong, whether it's our fault or not. If the patient does not feel welcome and the patient does not feel comfortable, they'll come up with reasons to bring a lawsuit, as opposed to responding. They'll come up with a reason. Okay, I didn't like it there. I didn't like the way I was treated there. Even if everything was done appropriate, then the likelihood of them bringing an action, if you treat them fairly and you treat them with respect, then it decreases the likelihood of them bringing the case. And there's been plenty of studies that support that. So from our perspective, I understand, and believe me, I know you're very busy. I have a sister and two sister-in-laws who are nurses. I know you guys work very, very hard, but if you could take that extra 15 seconds and make the patient feel welcome and listen to what they're saying, it'll help you. The other thing is, the medical record is where these things start. Okay, so the medical record is the starting point of all litigation. What the plaintiff does when they get contacted by a patient, the first thing they do, and Barbara can tell you this, is they send an authorization to the hospital saying, give us the records. Because they want to look at the records, they want to get the records to an expert, and they want to use those records to try to criticize the care and treatment. The record is helpful. It also can be a weapon that we use. The record is the contemporaneous journal of care. In other words, what's going on at the time is recorded in the record. So the plaintiff can say whatever they want, but if we have a good, solid record, it helps us defend the hospital. If we don't have a good, solid record, then some of the allegations that the plaintiff make, even if they're totally untrue, we have a hard time refuting. It's created in the absence of litigation, and that's important, because if I can tell a jury, this is the record that was prepared by Nurse Smith. She prepared it on June 19th, 2019. She didn't prepare it in 2022 when the plaintiff brought the lawsuit. So this is an accurate reflection as to what was going on at the time. That helps us. It also lends credibility to you if you have to testify as a witness. I made this note at the time of the treatment. I didn't make this note in anticipation of litigation. I did not make this note because I thought someone was going to sue the hospital. I did not make this note to cover myself or make sure that if something goes wrong, I'm free and clear. I made this note as the nurse caring for the patient. That is extremely helpful to us when we're defending the hospital and defending you guys as the matter goes forward. The other thing is, memories fade, and there's no doubt about that. I did a deposition yesterday where I represented the physician, and every answer he wanted to be, I don't remember, I don't remember, I don't remember. Because he didn't remember. It was a routine case, and something happened the next day when he was gone, so he didn't remember anything. But we had the record to support where he was, what he did the day before, and support the whole concept. And at the end of the deposition, I feel pretty good that we're going to end up prevailing in that case. So you can't rely on your memory, because you guys see hundreds of patients a week, and you see thousands of patients a year. And if I were to come to you 3.5 years later and say, okay, tell me what happened with Mrs. Jones, you're going to say, I don't remember that. But then when we go through the record, if you have good notes and you have good information in those notes, and you keep contemporaneous records which are helpful, then that'll enable us to defend the case even though you don't remember the patient. And also, sometimes when you look at the notes, you say, oh yeah, I remember Mrs. Jones. She was this and she was that, and we had a nice conversation about this and that. And that kind of helps with regard to developing a relationship and also developing a situation that the jury understands what's going on. Juries do understand that you're not going to remember every patient when you see so many. And that's why the medical record is so important in regard to defending this case. Now, the medical record is the best evidence in litigation. In other words, if I have a good chart, it helps me defend the hospital. It enables us to reconstruct the course of treatment. It also enables us to assist you and you to assist us in defending a case should it get to trial. Now, what we want to do is we want to prevent these cases from ever getting to trial. We want to prevent these cases from ever getting brought. and we're going to get to that in a little while. But the chart must be contemporaneous. In other words, you make the note at the time you're treating the patient. It must be clear and comprehensive, okay? And again, I can't say this enough. I know you're very busy, and I know that your first focus is to care for the patient. But if you don't do it now, I'm going to ask you to do it in the future. Make sure you document what you do. Make sure you document it well, okay? Don't leave anything out. I know you can't spend your entire shift writing notes, but there are some information that you know, and in the Zero Harm Initiative, you want to make sure that you make notes to show that our objective is to make sure that this patient is taken care of. And the way we do that is we take care of the patient and then we document it. If there's a sheet that's supposed to be filled out, if there's guidelines, and you know there's guidelines and protocols that we have here regarding skincare, you have to follow the guidelines. If we don't follow the guidelines, it makes it very difficult for me to do my job and help the hospital out as far as saving money and preventing lawsuits. If you make an addendum to your note, please mark it as an addendum and put the date and the time. So if you make a note on Tuesday morning and then you realize I left out something, and you go back on Tuesday afternoon, just call it an addendum and make the note. And put it in the chart where it belongs. Don't squeeze it in under your note. Put it in if there's another note next to yours, put it next to that so that we can use that. Because again, it's contemporaneous. It's not something that was written after the lawsuit started and what happened. And the other thing is, I have here not self-serving. And we're not looking to cover our butts here. We're looking to take care of the patient. And a self-serving note is seen as a self-serving note by plaintiffs, by plaintiffs' attorneys, and by juries. So a self-serving note doesn't help anybody, and believe me, it doesn't help you. If you have a self-serving note, you're going to be up on that witness stand, and the plaintiff's attorney is going to go round and round to show how it's a self-serving note. The idea is to take care of the patient, and the way we do that is we make good, clear, concise, and comprehensive notes. Okay? This is a thing. This is a little thing. I had another presentation. The user manual for the electronic medical record. The electronic medical record is designed to make things easier, and I'm convinced from talking to nurses, talking to doctors, talking to everybody, it has not made things easier, it's made things more difficult. It's supposed to make things more convenient. When you use the convenience aspect of an electronic medical record, it actually is more harmful than good. There certainly are a lot of good qualities to the electronic medical record. And I'm not saying we should go back to the written record because it is convenient. But using drop downs and using just repeating what's above is never beneficial unless that's what's really going on. So when you use the electronic medical record, use it, but use it properly and make sure the information that you need to portray is in there. This is New York. Somebody's always at fault. Okay? I'm not sure who was in the booth first, but you know, I'm sure that in this case, both drivers ended up suing and what have you. But this is just an example that there are people out there who are looking to bring a lawsuit. There are people out there who would never bring a lawsuit. I used to tell people all the time, my mother, God rest her soul, wouldn't sue anybody no matter what they did. And there's 10% of the population that feel that way. If they go to a hospital or they go to a doctor or if they're in a car accident, they just don't feel that they should sue. There's 10 to 20% of the population that would sue no matter what. Everything can be done perfect and they're going to bring a lawsuit. What we have to work on is the 70 to 80% in the middle who sue when they feel that they're wronged. So we have to make sure that they don't feel wronged. People understand, not the 10% or 15% who are going to sue anyway. People understand that not everything is perfect. People understand that things can happen and it not be somebody else's fault. But we have to make sure that we do what we must do so they don't have an excuse. Somebody's trying to get through from upstairs. So they don't have an excuse to bring a lawsuit. Best advice, avoid lawsuits. Communicate. I said that before. If you can spend an extra 15 to 20 seconds talking to or listening to the patient, that'll be beneficial. Tell the patient what's going on. Tell the patient, I noticed you have a little redness on your backside and we're going to start treating it. because I can't tell you the number of times where a patient testifies at the deposition. You know when I found that I had this? When I was at the rehab center and they turned me over and my daughter saw her for the first time and she went, oh! Okay, so communicate with the patient, and if there's something that happens, tell them it happened. Use the resources. If you see something that you think requires something to be done, go to your supervisor, go to risk management. We are, as I said, we're right down the street. I have a very good relationship with Barbara. If she needs me, she knows she can call me. So use those resources, because it's better, as I said before, it's better to get ahead of it than get behind it. Use common sense. And that's what I mean, not self-serving notes, but complete and comprehensive notes. Put down what you see. If you do a skin assessment, put it down. If there's a checklist that has to be filled out, please, please, please fill it out. I know it's just a thing in the record that's not important necessarily at the time you're caring for the patient, because you did a skin assessment and everything is fine. Please fill it out. Because if 5 days later the patient has a skin ulcer, they're going to say, well, it started back here and this nurse never checked out the checklist and never filled out the skincare report or what have you. There's guidelines, there's protocols, you got to follow them, and if it says on a daily basis you have to fill this sheet out, I'm asking you to please fill it out. Okay, I think it would be nice if we were sitting in a bar together having a beer. You don't want to be sitting in my office having to discuss what happened in a particular case. That's never fun. Second best advice is to win lawsuits. Again, you see, communicate is in both spots. Communicate with your attorney, communicate with risk management, communicate with anybody else that's involved. Once a lawsuit starts, don't communicate with your other nurses unless you are with the attorney. Don't communicate with the patient, obviously, and use the resources. Again, same thing, and again, use common sense. Where do you want to spend your time? Good time, bad time. You want to avoid that, okay? Avoid the courtroom at all costs. Nobody's having fun there. The only people that are having fun there are the attorneys, and that's not always funny either, depending on who we're assigned to. But you should enjoy your work. You should get some reward out of your work. You should like what you're doing. And if you do, and you do a good job, then you're going to be in the good time section. I can't guarantee you that if you do your job and you do it well, you won't end up in the bad time session, but it's much less likely, and it gives us the opportunity that at the end of that bad time session, we win the lawsuit and okay, Bob, it's not working. There we go. Okay. The final thing I'm going to talk about before Joy talks about the actual record itself is the biggest killer, or one of the biggest killers we have in going to court, is when someone rewrites the record or adds to the record. And that's why I said if you do an addendum, don't squeeze it in. Just do a separate note. Oh, I meant to write a note on the 20th when I saw the patient and there was room, so I put one in this open space.
That's when we had a paper record, but now we have EMR.
Right. And the EMR, you'll be making the record contemporaneously, but again, if you have to do an addendum, you have to do an addendum. Okay? Despite the fact that it's not noted anywhere, the patient had an ulcer when he arrived in the unit on his sacrum, which I personally treated every day. Okay? Now, my concern, and I've spoken to Barbara about this several times, my concern really isn't when the patient gets to the hospital, because we do a pretty good job of skin assessment when the patient arrives, so there's no doubt that that's done. My concern has always been when I represent a hospital, and then the patient goes to a nursing home or rehab facility. When the patient leaves the hospital, invariably the patient will have a stage 1 or stage 2 ulcer. And somehow in the ambulette between the hospital and the rehab, it turns into a stage 4 ulcer. So I'm in favor of taking pictures. Now, that won't be my decision, but the hospital may be moving in that direction. I'm in favor of when the patient is discharged to rehab, take a picture. Because if the rehab's going to say that it's a stage 4 ulcer, and we have a picture the day of discharge, yes?
We often start taking pictures.
Okay,
Yeah.
okay, good.
We have
So,
a pilot starting at Good Sale.
okay, perfect. So I think that'll help us, and it'll help me defend you guys, because if you guys are writing it's a stage 2, and the rehab says it's a stage 4, what plaintiff's attorneys do is they say, well, take the rehab's argument and say that the hospital didn't do it correctly. It's always interesting when you represent a hospital and the rehab attorney says to me, well, it started at your place, so you're responsible for it. And I'm like, well, no, that's not how it works. But it makes it easier for me if we can establish that when we gave the patient to them, the patient was in very good shape or fairly good shape, and then if something happened, it happened at their place. Okay, so what I'm going to do now is I'm going to hand it off to Joy, and she's going to talk a little bit about documentation in addition to not doing it this way. And then I'll get back up, and Joy, I hope you can get this thing to work. There you go. I'll get back up, and we'll wrap this thing up. Okay, thank you.
Okay, so now let's have fun with decubitus ulcers. Okay, I have to just disagree with one thing. I'm not quite certain that all the assessments that I see in your records, the skin assessments, are really all that good, particularly the incoming assessment. I find that in a lot of St. Joseph records that I review, there is no indication initially of any kind of skin issue, and then all of a sudden there's a big concern because there's a skin issue. So we're going to talk about how to document it appropriately so that we can best represent the hospital and protect you and the care and treatment that you're rendering. So let's just put some disclaimers on this before we start. I recently had a conversation with a nurse from this facility who said to me, if our notes are too good, we're not doing our job. I understand that. And you absolutely have 1,000 other things going on that are more important than actually writing down or checking off in the EMR what's going on as far as your care and treatment. I had another nurse tell me, well, of course we do that. Of course, if there's an order in the chart to turn in position every 2 hours, of course we do that. So we don't need to write it down because of course we do that. That's not how a plaintiff's attorney is going to approach this case. If it's not in the chart, it's going to be presumed that you did not do it, and it's for us to establish that you did do it. So the keys to really good charting are assessment, documentation, and detail. Now, St. Joseph Hospital has a set of policies and procedures with respect particularly to pressure ulcers. I don't know if any of you are familiar with it, but the next few screens are going to tell you exactly what the policy of the hospital is with respect to your actions for pressure ulcers. This document, this policy, is the second thing that plaintiffs' attorneys ask for. First, they get the chart and they evaluate what they think happened. Then they ask us for the hospital's policies and procedures regarding the case. And they sit with the chart and the policies and procedures and they check to see whether they align, whether you did what the policies and procedures require. So the first thing that it requires is assessment of the patient's skin. The patient is supposed to be assessed when they come in the door, when you first have an interaction with them, and they're supposed to be assessed every time they are transferred from one unit to another. They're also supposed to be assessed at the end of every shift. So you should be doing, according to the policy, you should be doing an assessment when you start your shift, and you should be doing an assessment when you end your shift. That would be wonderful for us because then we would know what happened during the 12 hours that you were with that patient. I saw this when I started. This is the condition that it was in when I turned over the patient to the next nurse. You're supposed to notify the doctor of anything that you see that may be indicative of a pressure injury. You're supposed to obtain orders and document the EMR. I know that most of this is stuff that you all do standardly. You're supposed to assess the injury for signs and symptoms of infections, whether there's an Escher, and you're supposed to notify the doctor of anything you see. You're supposed to ask the patient if they've been cared for in the wound care center, because if they have been, then the wound care center is supposed to be alerted to the fact that the patient is now inpatient. They all need to be assessed for pain, which I know that you all do, but for a pressure ulcer injury, it's because they may need to be pre-medicated before the treatment begins. There's a nutritional consult because we all know that nutrition and pressure ulcers go hand in hand. There's supposed to be a sign posted for turn in position. Then you're supposed to initiate the skin bundle orders, which are, I understand, are a check and form orders. Then you have to add the LDA to the skin assessment if you see anything. And then you have to document the care in 2 places, in the flow sheet under the pressure ulcers. Now, I've seen your flow sheets, and a lot of you do really great documenting, solid information on all of the aspects of the flow sheet. Some of you do not. And the problem that we have is that when there's a change, when I'm reviewing the record and I'm going, okay, stage 1, stage 1, stage 1, stage 4, I need to understand how that happened. I need to understand the care and treatment that was given that brought us from 1 to 4 in 36 hours, 48 hours, or 2 weeks. We need to understand, so the documentation needs to be clear. All right, you're supposed to assess at every shift and with any change of status, and when the patient's transferred from your unit to another unit. All right, the policy particularly says that you are responsible to ensure preventative measures are in place for any patient at risk of a breakdown or with a breakdown. That's why your notes are so imperative in a lawsuit for us to review. All right? Again, to reiterate some things that Brian said, your assessment is essential for us. It's what you saw in the moment. It's what actually occurred. It has to be uniform. Everybody needs to describe a stage 1, a stage 2, a stage 3 the same way. Everybody needs to measure it the same way. I can't tell you how many charts I've seen where it was 2 centimeters one shift and the following shift someone measured it at 4. If there's a difference, if something has happened in the interim, you need to put a note in the chart as to why it is bigger on your shift than it is when you got the patient in the first place. Because we rely on these assessments. We rely on your descriptions. We rely on your measurements in defending the case. All right, so you have to document the date and time it was assessed, where it is on the patient, give some orientation as to where on the patient's body it is. You have to give your assessment of the staging, and then you need to describe it. Please, describe it as thoroughly as you can. Red in certain areas, purplish in certain areas, granulating in only this aspect of it, oozing in a different aspect, as much as you can. And then most particularly, the single most important thing that you will do is tell us, was this pressure ulcer present when the patient arrived at the hospital, or did it occur while the patient was under our care? Because it entirely changes the course of a litigation if it was something that we inherited or something that we created. I know that if there's an order, you're doing it. But we cannot presume that. If you turn and position the patient every 2 hours, at the end of your shift, please, turned and positioned every 2 hours. TMP, Q2. I don't really care what phrasing you use, but I really, really, really want to see that in a chart so that I can say without question, the nurses followed the doctor's order and did everything that they can. I think we're taking questions at the end. I'd be happy to. All right, turn in position. I know how hard it is, and I know that people are uncooperative, but it is essential that you do it. All right, details. What details does the policy of this hospital require? Length, width, and depth, we always see. You're awesome at documenting that. Is there tunneling? Is there undermining? Is there drainage? Is there an odor? If there's not any of those, I would love it if you would write there were not any of those. But I understand that if you leave it out, it means that it didn't exist. Is the patient in a wound bed? Do you think a wound bed needs to be ordered? Have you placed the order for the wound bed? What kind of treatment did you render to the patient, and what is the status of their dressings at the beginning of the shift and at the end of the shift? Yes, I am. Oh, no, got it. Didn't we do this?
No, you can move. Just keep, we're getting close to the end, so.
Yep. Okay, I'm back to you. As carefully and thoroughly as you can without endangering your patient's well-being is what we would ask. Thank you.
We're taking a little longer than we thought, so I'm just gonna speed through this. This is just a repeat of what we said. You know, communicate, describe what you did, detail compliance with the orders, and document turning in position. Okay, patient sues, negligent care and treatment, failure to prevent the development or enlargement or worsening of a decubitus or pressure ulcer, and they allege pain and suffering, and oftentimes this proceeds, most of the time it's an elderly patient, I should say, and oftentimes when they go to a rehab facility, there's multiple comorbidities. They have coronary artery disease, they have diabetes mellitus, they are not eating, they have mental status changes or dementia, and they just get worse and worse and worse, and they end up passing away, and the plaintiffs then come back and say this all relates to the decubitus ulcer. So this is what I said before, that the hospital has to pay out the initial amount of money on a case. So what we want to do is we'd rather have the money here to use at the hospital rather than give it out to a plaintiff. Best practice is what we talk about: documentation, take your time, rapport with the patient is important, but also make thinking part of the process. Put your note down and be thinking, what did I do regarding skincare? I know you have 1,000 other things to do, but this is important to us as part of the Zero Harm Initiative as well. Okay, here's some nice pictures that I got. And basically, these things are very, very effective for plaintiffs' attorneys when they bring lawsuits. And these are just some of the things. So I've always been of the belief, and I'm still of the belief, that nurses will get the benefit of the doubt if in fact you have to testify in a courtroom, okay? That doesn't mean that we can get away with things. What it means is, if you have good documentation and you testify regarding your documentation, even if you don't have a memory of it, nurses, more than physicians, will get the benefit of the doubt from juries. I think juries know that nurses are on the front line trying to take care of patients the best they can. So as long as you do a good job with documentation, and I think it helps to get rapport with the patient as well, because I've had patients tell me, you know, I'm not really crazy about the treatment I received at X hospital, but that Nurse Johnson, she did a great job. She really cared about what was going on with me. So that's something that we could do. And finally, nurses rock. So you have our full support. I told you I have a lot of family members who are nurses, and you know, we think you guys do a really good job. And what the purpose of today is to try to help you avoid meeting me in my office and avoid ending up in a courtroom. And the way you do that is, as we discussed, documentation, rapport with the patient, and communication where it's necessary, and obviously following the protocols. So now we can take any questions if anybody has any questions.